Hello. It's time for another exciting video. It's had a long day today. Got my butt kicked pretty good. Had some successes. That's an average day. I think they call it Wednesday. Um, this is a video on Midland Credit Management. That's a popular one. Maybe one of the biggest next to Portfolio Recovery Associates. They're both publicly traded companies. MCM and PRA both have a very pragmatic approach. Only one is represented by Stenger and Stenger, as I've said previously, Stenger and Stenger, which are in about 10 states, a law firm, collection law firm, are very reasonable. Midland Credit can be very reasonable until you push the wrong buttons. And where you push the buttons with Affidavit is, before I say that, this is collectionstop.com, law and lawyering. Brian Parker here. Hi. Doing a video. I'm giving information, instruction, entertainment, education. But most importantly, how about the free stuff? The free stuff is on collectionstopper.com, Podcast Plus. There's a ton of protecting yourself when you get that first letter, which is called a 1692G letter. Something's on your credit report. Maybe the same people that sent you the letter are on your credit report. Sometimes they put it on your credit report and don't send you that required first letter. I go in and treat that as a first letter, and I send a 1692 validation request to that. And I also send a dispute letter. I double dip under the FCRA and the FDCPA. You should know all those by now if you're just coming to this. Fair Credit Reporting Act, Fair Debt Collection Practices Act. When I say double dip, meaning that's two opportunities, attorneys to help your client, real people to help yourself. So, look, there will be word produced validation, cease and desist, dispute letters on Podcast Plus, all free, lots of it. I'm going to put up Midland Credit Management, a lawsuit from them from both Michigan and Florida. In fact, the Florida case I just finished, they kept telling me all the work I do in Michigan. They're all connected, and they all do the same goofy stuff. Meaning, I've got a little high tech since I've been doing this, and you will see before you now, Shazam, the first page of a Midland Credit lawsuit filed in Michigan, but it's the same crap filed in Florida. If there's no attorney involved, they'll get away with a lot of stuff. But that first paragraph, you're going to see it, and I'm going to read it. It'll say, plaintiff is authorized to file this complaint in this court. No kidding. Plaintiff owns portfolios of consumer receivables which it attempts to collect. Yeah. Same paragraph. Plaintiff strives to treat its consumers, such as defendant, that's my client, with respect, compassion, integrity when we're done suing you, or maybe before, hoping to provide mutually beneficial opportunities for consumers to repay their debts and attain financial recovery. Said no one. That's a bunch of BS. First of all, there's no court rule in this beautiful country of ours that allows that kind of compound, badly written, self-indulgent pleadings. It's specifically for the judge. If it goes into default and the compassion and integrity go out the window, that's what the judge reads, right? Oh, these good guys. So that's the first paragraph of that dreck. Then the rest of the stuff is worse in both the Michigan, at least in the Florida, and I imagine all over the country. When I say all over the country, all this garbage from Midland Credit Management, when I say garbage, I dealt with some nice people over there, but the things they do to people and the lawsuits, not so much, not very nice. It all emanates from Minnesota. When I say Minnesota, the whole thing with debt collection lawsuits, and you can go to my video, how to beat a debt collection lawsuit or how to handle debt collection, but specifically to MCM. See, each debt collector, debt buyer has this uniqueness about them. And in law school, they used to say, know the rules, know the corporation, know the personality of the corporation. I go, personality? But really, a corporation runs on the personality of those that run it. And you see that every day in the way similar cases are handled by different debt buyers. Someone's got a real problem with me, it'll emanate down the corporation, way down to the people that I'm dealing with, and they'll give me a hard time. Whereas the same case, same facts, I'm friends with the people, and I get my client a real good recovery right away. I'm friends with no one in that regard, but I get along, and I have to be pragmatic sometimes. But my goal on every case is to get the debt eliminated or die trying. With the Midland Credit Management lawsuit, you're dealing with the number one thing, and that's an affidavit. They've for years been under attack, and years ago, justifiably, I filed a class action or two against them because they had such a mill of affiants, who are the people that sign the affidavits, that know nothing about the lawsuit. And I'm going to show you how I know that. Or the person who they're claiming owes all this money. All the companies that are claiming gave them these old debts. Midland Credit Management does not originate anything. I use that word purposely so you've looked at my what is securitization video, both the long version and the kind of longer version. We need to get into that because that's where your new attack is going to come from. The originator of any debt is the company that you first contracted with to get the credit card. In this case, this one we're looking at a real case. This is a Capital One bank. That's a lot of debt out there, and Midland Credit buys billions of it. Their affidavit, is attached to the lawsuit. Why? Because there's no contract between you or your client and Capital One. So in Michigan, as I've said before, an account stated statute allows you to slap on an affidavit and say, hey, we're the guy that owns it, just trust us on this. So the burden of proof, and I'll keep repeating this, the burden of proof switches to the poor debtor, whether they're the subject of bad chain of title or they didn't even go with this debt because of identity theft. Now this affidavit, immediately when that's filed with the lawsuit, the burden of proof switches to the debtor, who now's got to do all this work, when the burden of proof for most Americans is, plaintiff, you've got to prove your case. I don't have to do a thing. Think OJ. Although they got him in the civil case, but a burden of proof in the criminal case. Similarly, in the civil case, they both have burdens of proof on the people bringing the lawsuit or the indictment. I think it's the Sixth Amendment or Fifth Amendment requires you don't have to do a darn thing. The person coming after you in a criminal case, it funnels down to civil with a lower standard of proof. Their burden of proof is by a preponderance of the evidence. And no professor in law school could tell me what that means, other than it's 51% more likely that your client is responsible or liable, as opposed to criminal, where it's beyond a reasonable doubt, which is just as nebulous, but seems so much further away than preponderance of the evidence. And that would be true. But there's still a burden of proof on the people suing you that with Michigan and some other states disappears or lands in the pockets and the feet of the poor debtor now that must prove that he doesn't owe a debt. It's not like he sued himself, and that's a good way of putting it. How come you get sued, so it's their burden of proof, but now you've got to get your way out of it, prove yourself that you did not partake in this thing that you never sued yourself about. There's a couple of weird things like that. So in this case, the lawsuit was filed by Midland Credit after the Minnesota. So the Michigan lawsuit was filed, and after the Michigan case was filed, and I am derelict in duty by not knowing when that happens. 228 is when this Michigan case that's going to come up on the screen, and then what's going to come up on the screen is the State of Michigan Midland Credit Management and Defendant Affidavit of Tara Grell. And she has signed an affidavit January 9th before the lawsuit is even filed. 2 months before, almost 2 months before the lawsuit is filed, claiming, and here's the thing, first brick, you need to look, remember we look for, a brick is not a wall, but many bricks do make a wall. They entitle the affidavit with my client's name as defendant and Midland Credit Management as plaintiff. So what? There is no lawsuit, so how can there be a plaintiff or a defendant? So how can they swear under oath that someone's a defendant or a plaintiff when the lawsuit that it's based upon, is it the chicken or the egg that comes first? I'm going to solve that problem right now. The lawsuit is the chicken. The affidavit is the egg. And the affidavit came before the lawsuit, even though the affidavit refers to the lawsuit that doesn't exist till 2 months later. In Michigan, 600.215 MCL, you have to file an affidavit if it's going to accompany an account-stated lawsuit within 10 days of that filing. Clearly that didn't happen here, but nobody's noticing. But you are, hopefully after this video and my how to handle a debt collection video. Also applies in my how to handle student loan videos, because as we've talked before, I hope you remember this, I just did one. A student loan lawsuit based on a private debt is nothing more than a Midland credit or a portfolio recovery or a Crown asset. Long time gone, tons of quirky chain of titles and members of somebody buying something and selling it, just like with Midland Credit. So they buttress, I'm going to try and use all these weird words today, buttress, support the lawsuit with an affidavit that was created before the lawsuit was even contemplated. And again, look for, and what you'll see on the, I hope I'm pointing to the right place, you'll see on the screen, I've underlined plaintiff, plaintiff, defendant, defendant, just so you can see what they're referring to the client as, even though they're not. And also look for the language. Language is important. And this is a tough nut sometimes with judges. They'll go, well, why didn't your client just pay it? And you go, oh, wait a minute, judge. She does owe it, but not to this person. I had that same thing happen to me today. Judge did not want to hear it. Although 2 cases before me, the judge actually reached out and helped the defendants in a case that went to a judgment, in one case 10 years ago. I come along and boom. So that's something what's going to happen. That's what the Court of Appeals is for. I'm going to use it. In this case, the affidavit, it's going to be on the screen. In the first paragraph, it says, plaintiff's the current owner, okay, and was assigned all the rights, title, and interest to defendants without naming the person, account. They do little things like that, and I've sued them even in class actions over the years to fix a lot of the stuff. But there's still, even as I'm looking at this now, there's a bunch of quirky things. Quirky they are, correct and perfected chain of title, they ain't. So check that out. I always, as a matter of course, for example, this is Tara Grell. I will Google her name and find other affidavits that she's filed, assuming it's a female, and get her signature. And I've had cases where I cut and paste all these signatures an affiant had from an affidavit, and I line them up with the actual one. And you can see, you don't have to be an expert, that something's rotten in this case, St. Cloud, Minnesota, which, by the way, this is for a Michigan case. Why is that? When you try to depose the affiant, which you should, or do discovery, they give you a hard time. No, they're in Minnesota. Well, then don't file them in Michigan, is what I say. And that's a pretty good argument, a very quick argument, and I get to depose them. With COVID and Zoom, we get to Zoom them. Usually that's the grand compromise. I don't do that anymore because I want to be right in their grill, giving off the horrible stuff that I give off just non-verbally to make them uncomfortable. Why am I a bully? No, I'm defending a person that suddenly is getting sued for a debt they don't owe to this company, and they're supporting it with BS. Hey, man, I'm a reasonable guy until you start lying to me. I've said that in a lot of my videos, especially my how to take a deposition video. So get in the grill. In this case, get in Tara Grill. That's her name, Tara Grill. And compare her signature. There's all these fun things you do. I used to compare the notary. They have to notarize it for it to be attached to the account stated complaint. And I would find robo-signers. My heart goes like this. I'm like, am I really seeing that? But I touch my heart, and I can feel my heart going really fast because it just boggles my mind when corporations take such bad chances over $4,000 to $10,000, and you catch them robo-signing. Midland Credit used to catch them a lot. There's another thing that's attached to the lawsuit. You need a sentence to tell the truth. A lie is supported by paragraphs. Let me just say that. So not only do you have an affidavit attached to the lawsuit, then Midland Credit, and you'll see it's going to come up on the screen, then attaches a bill of sale. Okay, we got that you said that you owe it the first time. Then there's a bill of sale that shows up from Capital One, signed with electronic signatures, with things blacked out. If they're so pure and perfect, why do you need to redact things? But they do. Look for your, as I said before, your the ends of the addresses. Like they have data connectors here of many sorts. They're catching up to me and changing their stuff, but there's so much going wrong here in this bill of sale. Always look at your dates, because normally they'll say one thing is the title is moved over to somebody else on the 20th, and then the person that gave the stuff to somebody else has already gone and given it to another party on the 18th. That happens with regularity. It's kind of fun, actually. I admit to you, I didn't do my homework today. I'll tell you why. The next, I'm sure it's all true, they then add another affidavit. This is the same lawsuit for $3,700. Oh, what webs we weave when we practice to deceive, perhaps. Why do you need all this support over $3,700 if the affidavit from your actual company is correct? Now they have an affidavit of sale of account by creditor. It's like they're winking, going, no, seriously, we own it. No, seriously, we do. Here's our third affidavit. I think this one's from an attorney this time. Now, here's the funny thing. It's going to come up on your screen. State of Virginia. This can't be right. I apologize if this is correct. It says State of Virginia, County of Gooch Land. It sounds like some from a Jackass. There's, I can't say it because it's sort of obscene, but the word Gooch Land. I bet that is a county and it's all good. And there's a reasonable explanation for that. It just, sometimes things like that come along. I've seen things like that are totally false, and someone had put it in an original draft as they're writing it and forgot to fix it. You'll see stuff like, so I saw County of Goochland. I'm sure it's correct. Again, what you do, in all seriousness, if you can be serious, check the signatures. I swear to you, 75% I check have a difference in other documents, and you put it in there. That's another brick, man. Say to the court, this seems a little strange. Who changes their signature? It happens. So if someone is volunteering stuff, and that's what Parker's rule is, you get in trouble if you volunteer. If you volunteer as a Good Samaritan from one of my first videos, now you have rights that you have to both, you have duties because you volunteered, and there are certain rights that have to be upheld. Well, guess what? There's another affidavit in the same $3,700 lawsuit, this time with some weird signatures from an attorney this time. Honest, we really own this debt. Honest. They have another, this one's certificate of conformity in bold letters. Nothing else is. That's like saying to the judge, look, seriously, we're conforming and confirming. Is it conformity? Conformity. And this is from Virginia again. And the other question is, why do you need a Minnesota affidavit, a Virginia affidavit from Goochland? Wait a minute. I think we have another state represented. I don't see. There's really no company. So there's at least 3 states with Michigan involved. Wink, wink. We really own this. And this certifies that a William Winston Page is a notary republic. That's all it's saying. And this thing is done in the Commonwealth of Virginia. I don't know if it's Goochland again. It'd be funny if that really... Oh, this one's from an attorney. It's from a James Olmsted, who probably doesn't even know, perhaps he does, that there's mass quantities running around. So 1, 2, 3, 4 affidavits to say, yeah, we really do own it, if you don't believe us. So that might be enough, right? But their complaint, again, the Fund Midland Credit, and watch for this too, says, and you'll see it up on the screen, the attorney then declares, under penalty of contempt of court, that to the best of my knowledge, information, belief, this is good. There's good ground to support the contents of this pleading. Okay, we believe you. That's the fifth affirmation that we really do own this debt. Guess what? They didn't even sign it. They just wrote copy. And that's what the client was served with. And hey, it's going to be up on the screen. It says, please understand, there's that nice guy again as we're taking your money. This communication is from a debt collector. It's an attempt to collect a debt, and any information will be used for that purpose. You've watched my How to Defend Against a Collection Lawsuit video. Specifically, the FDCPA, which regulates all debt collection, 1692 E11 says, don't do this. So what's Parker's rule if you volunteer to do something? When you volunteer something, which you're not required to do, in this case, you have made a collection communication, which under 1692G, which covers all validation, says pleadings are not to be considered the initial letter or communication that kicks off all your validation rights. However, in the pleadings, they've added an E11, which called, here we go, look it up, a mini-Miranda. That means this is now a collection communication, which the law said, don't worry about it. Say whatever you want in the pleadings, just don't say what you're saying. So now they've voluntarily done something that puts more rights and duties. You can come after them saying, where's my 1692G notice? Technically, if you may recall, under 1692G, the debt collector, upon first notifying you they're pursuing you, and it does say, we are debt collectors, and that's what E11 requires, they say. This is an attempt to collect a debt. You've got 5 days to tell people their rights. So if this is your first communication with a debtor, and by the way, a large majority of debt lawsuits come first. There's no letter, because it's a waste of money to send the letter, to have the guy, because people are validating now. So now that puts an English expression, spanner in the works. It grinds them to a halt, because if they ignore the validation letter, that's $1,000 they got to pay, and it may screw up their eventual lawsuit. So a lot of them jump right into the lawsuit, and I think that's what's going on here. And they figured, we'll throw this in there too. So we've done what we're supposed to do under E11. But under E11, it says specifically, don't do this in a pleading. You initiate the 1692 collection communication first note under 1692G, and then you must give them their rights, them being my clients, your clients, the debtors. If you don't, you violated the FDCPA. So again, never volunteer anything. I'm sorry that sounds so cynical as an attorney. Don't. It doesn't benefit you. What do they say? The road to good intentions? There's no good intentions here, but I'm just saying don't volunteer. They will include what's called a data form. I have a wonderful story that I've told in my, again, debt collection lawsuit, how to handle it. This gentleman owed $25,000 and the judge really did him bad. And it's the case is called Midland Funding. They changed the name after that case. Midland Funding versus Bassett. And it's a Court of Appeals opinion, second opinion. He won twice at the Court of Appeals because the judge was so interesting. And eventually the Court of Appeals just took the case away from the judge. But it's all about the data form. The interesting thing is Midland Credit is loading up all this information as though it's legitimate, no signatures. We'll say that this data form, and the data form is going to come up, is an assignment, proof of an assignment that your debt came along with all these 4 affidavits and 3 bill of sales. It isn't. It's created actually by Capital One. So for you legal beagles, look at 803.6 in Michigan, MRE 803.6, MRE 911.912, which requires that you have documents under oath created by someone with personal knowledge. That person's not going to show up, so they're allowed to slip in their information saying we have personal knowledge if they swear under oath. This information is true. There is no information. So that's kind of why you're seeing James Olmstead and somebody notarizing an affidavit of sale of account of creditor, bill of sale without a notary. They just can't help themselves. They know they're doing wrong. So instead of just saying, if you will, the truth, it's better to do a couple of paragraphs trying to convince the judge that what you're saying is the truth. The Brown Bark case is a very important case, so important that I have not, I don't have it available here right here. Hold on, let me see. Answer the MCM lawsuit. Let's see if I was smart enough to. Sorry about this. I'll be quick. Oh, there it is. All right, so the Brown Bark case, which is in all of my answers, go to collectionstopper.com, podcast plus. There will be answers from the website specifically on this case. I've used the case as a model for you to see and go and see what tangle webs they weave. But look for the Brown Bark 2 LP versus Bay Area floor covering and these cases and Design Inc. et al. Court of Appeals case. You have to say and prove that you own the debt. And there are major collection law firms that have looked at this case and have opined, had blogs on the case saying, yeah, that's a great case, which I use against them. Because the case says it's really tough to prove an assignment. And maybe that's why they're putting so much stuff that doesn't count and hoping that the judge is just going to go, all right, there's a lot of stuff here. Guess it's true. By the way, this particular case, I can't say the gentleman's name or that he wouldn't mind, but the case you're going to be looking at is as a result of ID theft. It wasn't my client's case or debt. So weirdly, they have 6 affidavits or 5 affidavits saying, 4 affidavits and 1 lawyer saying, yeah, absolutely it's true, for something that is absolutely false. And my client had an ID, had police report and all this stuff. That went away quickly, which should for 3,700. So your argument in defense, as I'll put my answer on the website, is no real party in interest. They don't have standing. When you defend these cases, look at my answer, and I've said this in my other videos, you have to have your counter affidavit. When you do that under the account stated statute, the burden of proof goes right back to the people that brought the lawsuit. Now they're on their heels, and now they've got to prove something that in this case, and in most cases, my client didn't know. Midland Credit Management, I think at one point was filing like 160,000 of these in the state, in one state. And they all are just going crazy right now. You can go crazy and make them crazy by going to collectionstopper.com. And now you know how to fight a Midland Credit Management. My favorite expression is, hello, it's right in front of you. And I want to yell at a judge sometimes. Today I had that, where specifically you could see that I should win this, and the judge looked at something else. And when I reminded him for the 7th time that he's missing it, I wanted to yell, hello, it's right in front of you. I yelled something else, and I got admonished. I get frustrated. I thought I'd get more mature as I got older and got gray hair. But I'll do an appeal on that, and I'll learn more. And I'll tell you, when you appeal and you win, and I will, I know this stuff better than, I do know this stuff better than judges. I have judges calling me and go, hey, I got a case coming up on the down low. How should I look at this? And the cool thing now is what I can tell you. I'm going to tell you what I tell judges. Go to my video. They're boring. You watch them in the morning because you fall asleep at night. Don't drink. But judges get back to me and go, you nailed it. That's what the guy was doing, and I knew it, and I filed this. So I know better than most judges. I feel like a shithead saying that. But I do. What am I supposed to do? I really do. Maybe it comes off sometime. And I want to stop cases sometime and say to the judge, look, hold on a second. Let me just show you where you went wrong. But you can't do that. But I know this stuff, man. I've been doing it for 30 years. I've filed class actions on stuff that is still coming down the pipe. This case I just showed you, a lot of that stuff was fixed with some of my class actions, and it's still kind of weird. So my point in having an ego trip with you is, give me a call or no, email me if you want to do what judges do and contact me for help. I won't practice in your state. I'm not practicing in your state. I'll give you an education, and let's do this thing together. If you see something that I missed, let me know. Very briefly, in that first paragraph where they're just patting themselves on the back and saying, we really dig the consumers and we tried everything we could not to sue them, where's our money? I wrote to the court and said, under MCR 2.113, this is not concise and held within one, small sentence like it's supposed to. And that's a brick, but that's another brick of a very large wall that they present you. And it's always the truth. You will win your case with their documents. You may not win today, but you'll definitely win tomorrow. And you'll definitely win most of the time. It's like you're counting cards at blackjack. As I've said in videos before, I figured out how to count cards, and I'm a dummy. I'm supposed to put myself down once a video. And I had the answer, and my money that came in improved, and I was risking less. I had no fun. This is fun when you count the legal cards here, because you're using their cards. This is like being able to play poker and their cards are transparent, because at the same time they're not being transparent. In order to cover up the lie, they produce all these affidavits, which can't possibly be anything but a bad idea. But it's a good idea that you came and watched this video. I hope it's helpful. If you think I missed something or you want help with something, comment. I'll get right back to you. I'll email you. But you know what? you could avoid looking at this face again and just go to collectionstopper.com or one of my great videos on validating and disputing the debt or handling a class action lawsuit. Go to the ones on securitization. I can talk about securitization in every debt collection lawsuit, especially MCM, and I don't have to. Their debt buying cases will go away. But that's my go-to reliever, my plan B if there's a problem. But I don't believe in plan Bs. I think if you've got a plan B, you don't have a plan A. So what I like to do is bring it. But I'm not doing that in this video here. But in this answer, I've written, hey, here's what you did. There's a secure trust, yada, yada, yada. And there's a big chain of title issue, which whether you're securitizing, look at my video on how to handle securitization. Whether it's securitization or just plain chain of title, it's all about the assignments, baby. All right, you go have yourself a good day. I hope this was helpful. Go get MCM before they get you. Because remember, they're already getting you before they even file the lawsuit. They're talking crap about you in an affidavit, a sworn affidavit, that it can't be true under oath, as they say, because the lawsuit that they're referring to by calling you a defendant hasn't happened yet. All right, enough already. It's, oh my God, I'm supposed to do 15. It's 36. Hey, that's more value for your dollar. Again, this is for fun education, but information and education. Call me if you want more education or email me. And I thank you very much.